Gavin, you did miss one of my favorite quotes about government, and I'm gonna throw this one out. You know, we're sitting on 4 million pounds of fuel, one nuclear weapon, and a thing that has 270,000 moving parts built by the lowest bidder. Makes you feel good, doesn't it? Anybody? Yes, very good. Right over my table. And what's the life lesson? I see it as sometimes competition isn't the best. Sometimes it's cooperation rather than competition. And that's kind of the story of USIP is 20 years ago, what counties saw was competition wasn't doing it anymore when it came to protecting themselves from liability claims and property claims and workers' compensation. The prices were out of control. And a lot of areas like the jails and other law enforcement agencies couldn't get insurance at any price. And that cycles through every decade or so that the insurance market decides that it's just not a good risk. We don't want to insure people who carry guns on their hips every day. We don't want to insure health departments when Ebola is coming onto our shores, things of this sort. And so what commissioners and county attorneys and UAC did 20 years ago when they couldn't buy insurance anymore, it just wasn't a good deal, was every county is able to self-insure, technically under the statute, but financially not. But as a group, through cooperation, they can all self-insure together. And that's what USIP is, the Utah County's indemnity pool, is the counties self-insure together as a group and decide what coverages they're going to provide themselves, at what price, and under what conditions. And my staff and I, we just run that organization for you and make sure that when you have a claim that you get the defense counsel that you need and that you get everything paid for and that there's not an obstructionist adversarial relationship between you and an insurance company reading a policy and trying to do best for their shareholders. We're getting you the money that you've set aside to make sure that you are protected from those types of losses. So I'm going to talk a little bit about the liability issues as newly elected officials. So raise of hands, who all has actually been named in a lawsuit where you've been sued before? Come on, the election's over. I can ask that same question of this same group a couple years from now, and a lot more hands are going to go up in the air, people. You've got a big target painted on your back. You're a deep pocket as a county, and you will get sued. And we're here to not only take care of you when you do get sued, but try and help you from getting sued in the first place. So let's talk real quickly, just give you an idea of the areas that you need to really watch out for. These are the areas that counties get sued for most. Personnel. How many of you are experienced employers? Okay, just a handful. This is the area that now you've got some responsibilities to make decisions about employment and people's raises, people's promotions, people's demotions, people's terminations, people's hire, and you need to make sure that you're following the advice of your experts there. The termination process is one that almost every termination, it seems like lately, ends up in a lawsuit. It's kind of a free stab at it for most employees. Wouldn't you agree, Joe? Yeah. And the area that you get caught up most often where you're going to end up having to bring that employee back, pay them their back wages, and live with them is when you fail to follow your own policy. So two things in that area. When somebody asks you about, we want to move forward with terminating this employee or demoting them, or we want to hire this person, but there's some odd circumstances, the question you should have is, what does our policy say? And for that situation, follow your policy. If you don't like what your policy says, change your policy, but you'll have to do it after this one situation. That's the best advice I can give you right now in general for personnel issues. Law enforcement and corrections, another area that a lot of lawsuits. When people get put in jail, when their cars get confiscated, when they are put off by being pulled over and their time is taken while a ticket is written, or a dog sniffs their car. They don't take lightly to that, and they're going to sue. Again, shootings and searches, big areas that we see. And in the corrections side, the big areas are suicides within the jails and improper medical treatment. Now, bad news is we get a lot of claims in this area proportionately. Good news is when I compare myself, Utah, to other states, Utah sees very few of these types of claims. The corrections in county jails here in Utah are really well thought of throughout the country, and it shows in the number of claims that we see. When I talk with pool directors from county organizations, county pools across the country, they're really can't believe that we have as few claims in this area as we do. You know, Utah actually wrote the jail standards. USIP and UAC helped fund writing the jail standards for Utah corrections facilities 15 years ago. And just last year, those standards, after they've been updated over the years, were just adopted by the National Sheriff's Association as the national standard. So we're leading the way in that area, which is good, but you're still going to see these issues. So keep close with the sheriff on these issues, and make sure you understand how sensitive that area is. Land use is another area that we see not a huge amount of claims. I mean, obviously we get tons of auto liability claims. I'm not even going to talk about them because it just happens. You bump into people, and sometimes you're at fault. More than half the time, unfortunately, the county driver is at fault in the auto accidents we see. But land use is one where we don't see it as often, but it's for huge amounts of money. And some of you already know that you are involved in these types of claims where it's a developer that isn't happy with the fact that they put some money and capital into your county and now it's not paying off the way that they thought it would. A group home that thinks that they should be able to have an unlimited number of problem children move into your community. You know, these things that are really tough issues to deal with, that the dollars are significant when we get involved in them. So those are kind of the leading areas that I'm just going to warn you in the 50 minutes I have, those are the areas to be most concerned about when they're brought in front of you as officials. Quickly on the procedure for lawsuits, here in Utah, a claimant that has any claim against the county has to file a notice of claim with the county within 1 year of the occurrence that damaged them. And that rule has been upheld by the courts very strictly. There was just a Supreme Court case just recently of a school district where the person sued or filed this notice of claim 1 day late. And the argument was, it's only a day, come on. Yeah, I mean, this is a really substantial damage claim, and we only missed it by 1 day, and the Supreme Court said, sorry, we've already had cases with cities and already had cases with counties. 1 day is 1 day. If you don't file it within a year, you're done. You cannot file a lawsuit unless you filed this notice of claim, and that's the process. They can't file a lawsuit in court until they've given you notice first. Once you get that notice, you have 60 days to make an offer of settlement, or if you don't make any offer, if you don't do anything, it's deemed denied after 60 days. And then after that 60 days runs, or you deny it, if you choose to kind of push up the schedule and not wait the 60 days and send them a letter saying, we don't see that we did anything negligent, we're not going to offer any settlement, then the clock starts ticking and they have, again, a year from that denial date to actually file their lawsuit. And same thing, the courts uphold that very strongly, that they miss it by a day, their lawsuit is thrown out. So you've got some real good protections there. At least you know what's coming is the whole theory behind that it isn't years after they were damaged that they can come back after the county, that they have to let you know that they've got some damages that they want. Through this process, one of the things that I know as elected officials and newly elected officials is you want to keep your your reputation as sparkling as possible for reelection a few years down the road. And settling claims doesn't sound good. It doesn't look good. It looks like the county did something wrong when they settle a claim. But under the statute, if you settle it in this 60-day period, the statute says that is not an admission of liability, and it can't be considered an admission of liability. So at least technically, that's not what you're doing. You're not admitting liability. So consider that. And your county attorneys will help you in that area of whether or not it's a situation to consider settlement or not. Again, we follow your direction. We don't settle claims. We don't give nuisance value settlements. That's part of the reason, beyond just not being able to get coverage at a good price elsewhere. Commissioners were also upset that insurance companies would settle those claims without even asking them whether or not they had done anything wrong. They're looking to get rid of that claim as cheap as possible. And that doesn't always look good for you when over and over again your claims are getting settled and people are getting nuisance value settlements for something that you didn't do anything wrong. So USIP doesn't do that. And we can look back and look at other entities that insure, and clearly that has led to reduced numbers of claims that we see, because the big law firms in Salt Lake that you see late night on TV saying, call us, we'll get you your money, they don't even bring lawsuits against us anymore because they know that they're actually going to have to go to court. Can you imagine that? That they wouldn't just get a check, that they're going to have to actually fight in front of a judge, and they don't want to do that. That's not how they make money. So it's paid off by not making those nuisance settlements. But if it's a situation where clearly the county made a mistake and it's going to be better for everyone to settle it out, we'll work with you at your direction to get that done. Immunities and tort caps, another oddity of government life. Counties enjoy numerous entities or immunities. Back prior to the 70s, you couldn't sue a county. You were immune from any lawsuit. Can't sue the king. But the federal government decided that, we do some things that people probably should be able to sue us for, and we're also going to extend that to states and local governments as well. So now you can be sued, but you can identify some areas where you're immune. And so the state's done that. And some of the big areas, to understand, there's a whole list of immunities, but in general, the big ones are for governmental function. If you're acting in a governmental capacity, you generally have immunity for lawsuit for that. When you're acting in your legislative capacity, you can't be sued generally for the decision you made as you created an ordinance or changed an ordinance, generally. Control of epidemics, which is an important one right now, isn't it? That if somebody sues you because Ebola came into your county, you can't be sued for that, says the statute. We'll wait and see. Proper seizure and forfeiture is another area that we see a lot of lawsuits on, unfortunately, that where law enforcement officials and tax assessors are seizing and forfeiting properties, and the statute says you can't be sued for that. You're immune from a lawsuit for that, civil lawsuit, okay? So that's immunities. If you have questions on other areas that you don't think you should be able to be sued for, let's talk, and we'll go into more depth on what the other immunities are. Judgments against counties are also beyond the immunities of the things you can't be sued for. You also are limited in what you have to pay in judgments against you as a county government. And this capitation of how much you can be sued for, or tort cap, as you'll hear it referred to, here in Utah, currently, if you damage someone else's property, the most that a judge can order as a judgment against you is $281,300. And these will be odd numbers because the legislature set them several years ago, and then every other year they're escalated by the cost of living. So they come out to be odd numbers. So that's why. So if you damage their property, $281,000 is the most that they can get. A jury may say you owe him $1 million, the judge has to say, yeah, but they're only going to pay $281. Injury to a person that you're found negligent for, the most that you're going to have to pay that one person is $703,000 currently. Yes. Yep. If there are multiple people injured in the same occurrence, so the bus crash, you have a bus full of kids going on the county ski trip through the recreation department, and they all get wiped out, the total in aggregate that the county can be sued for is $2.4 million. And all the families of the kids on the bus share that $2.4 million. But that's the most that you can be sued for. Okay? So those are pretty important issues. Now, that applies to state claims. You get into federal court, or if you have operations out of state, like you border counties that go across state lines, and we've learned this lesson, the other state may not, they may not recognize your tort caps here in Utah. They might not let you use their tort caps in their state, and you may have no tort cap and have an unlimited exposure. So that's why we do provide limits of liability above these numbers, because you can be sued in other states or at the federal level. So you need to be concerned about that. Okay? Defense of the county is a big issue again. We define or provide defense based on if the county is required to defend that employee, then we're going to defend them. We follow the statute. And under the statute, a county must provide an employee a defense with very limited statutory exceptions. You can't just say, well, I don't think he was working within the scope of his employment at that time, so we're not going to provide him a defense. He's on his own. Well, it doesn't matter if he was working within the course and scope of his employment. If he was working under the color of law, such as he was wearing his uniform at the time, then you have to provide a defense under law. Or you can agree to provide the defense on a, Corby, help me out, reservation of rights, thank you, which means if that person is found to have, one of the exceptions is if were committing a criminal act at the time, then you don't have to provide them defense. But generally, you're going to have to defend them until they've pled guilty or been found guilty. So you provide the defense on a reservation of rights. When they plead guilty or are found guilty, you can stop the defense. But until then, the county's required by law to provide that defense, so we're going to be there to do that for you. With your defense counsel early and often, don't wait until the lawsuit is filed to start talking to defense counsel. That's different again. One of the things that counties have that you don't have if you buy traditional insurance. A traditional insurer only lets you start talking with the defense attorney after the lawsuit is filed in court. We start letting you talk with the attorneys. The coverage agreement says when this notice of claim is filed, we'll start providing defense, but we also provide access to our defense attorneys to you at no cost before the lawsuit even happens. So when that department head comes in and says, I've got a really sticky situation, but I'm firing the person anyway, what do you think? You can get on the phone, call the attorney that's going to defend you, ultimately, and start getting the advice before you actually take that leap and terminate the person. Okay? And that's in all the different areas that we provide defense. So again, use those defense hotlines on any touchy situations. Again, just as Gavin said, I'd like to have those calls made through the county attorney's office. We're not trying to circumvent the county attorney's office. We're trying to support and assist the county attorney's office. Okay? Beyond liabilities lawsuits, very quickly, the self-insurance that we do applies not only to the liability but to the property as well. We cover all your buildings and equipment and contents. Then we self-insure a portion of that as a group, and then we go through a NACO program. The National Association of Counties has a pool of pools nationwide where all the county pools across the country get together and they self-insure for the catastrophic events. So we're doing it at both levels. So all the way around, we're saving money in that. Locally here in Utah, you're not paying commissions. You're not paying fees and on all of those things that you do when you purchase an insurance policy. And you're not doing that at the national level either for your catastrophic insurance. It's all done by county employees. We also provide joint purchasing opportunities, the biggest of which is our workers' compensation program. Workers' compensation is a really competitive area where companies are willing to lose money. Last year, the combined ratio for all workers' compensation insurers in the country, on average, was 116%. For every dollar they brought in, they paid out $1.16. They're losing money. But during that long time period that they're paying out those claims, they're getting a lot of investment income, so it's good business for them. They just need the cash in the door to invest and make 20, 30% on the money before they pay it out on the claim. Then they can afford to pay the 116%. So this joint purchase program through the workers' compensation group, workers' compensation is the largest workers' comp insurer here in the state. They were created by the state to cover the state employees. Counties and cities started joining in and being part of that, and eventually they mutualized. The governor still appoints the board of directors, but they're a mutual insurance company. They write business all across the country. They're like the 30th largest workers' comp carrier in the country. And we partner with them, and because we join together and buy one policy for all the counties, we're one of their largest clients. So not only do we get a huge discount for being such a large client, we also get a lot of input into the training that they provide and the rates that they charge for county employees and those sorts of things. So it works out really well to have that joint purchase opportunity too. And we do lots of other smaller joint purchase type programs. So when you have a question related to safety, training, risk management, insurance, and you wonder if you might be able to work with other counties to do it cheaper or better, that's what we're about. Give us the call and we can change our program and update our program to do that. Training is developed and provided specifically for counties. That all of our members are county and county-related entities, counties and special districts that serve counties, that counties created. And so training is provided throughout the year. We have training for facilities management to keep your property safe, training for fairs and special events. You know, we had 3 people killed at county demolition derbies this year. It's going to be pretty expensive for counties, so we do training with those people because of the claims we see there. Training on planning and zoning issues that we coordinate with UAC on to get that training to you because of the areas there. Personnel conference once a year. All that training provided to your employees. And again, it's geared towards exactly what they need as counties. So again, we work for you. This is a county-based organization. It's not separate from. We're an interlocal agency, as Carrie explained them. You know, where she talked about interlocal agencies carving out a piece of the county and providing a service to just one piece of the county, we go the other direction. It's all the counties working together as an interlocal agency. So don't hesitate to contact us. You don't have to try and hide things from us. The sooner we know about your problems and issues, the better we can work on them. So please don't hesitate to contact us and keep us involved in what's going on in your county. That's it.